A life estate is an interest in real property that's held for the life of the holder. Upon the life tenant's death, the interest passes to the remaindermen. In Browning versus Sacrison, we explore at what point a remainderman's interest vests. Kate Webb executed a will in 1943. She left her daughter, Ada Sacrison, a life estate in certain real property. Upon Ada's death, the remainder was to pass to Ada's sons, Franklin Browning and Robert Sacrison, share and share alike. Webb's will further provided that if either of her grandsons be dead, then the entire remainder was to pass to the other. All provisions of Webb's will excluded Franklin and Robert's father, Clyde Browning, from sharing in any interest in her estate. At the time Webb executed her will, Franklin was 20 and Robert was 13. Webb died in 1954. She was survived by Ada, Franklin, and Robert. Franklin later passed away while the life tenant, Ada, was still alive. Although Franklin was married, he didn't have any children. Franklin's wife, Georgia Ann Browning, filed suit against Robert and asked the court to construe the relevant provision of Webb's will. Specifically, Georgia argued that the language stating that if either grandson be dead, the entire remainder would pass to the other referred to whether the grandsons were living at the time of Webb's death. Thus, Georgia reasoned that Franklin's remainder interest vested upon Webb's death. Robert, on the other hand, argued that Webb's will granted each grandson a remainder interest contingent on their surviving the life tenant, Ada. The trial court agreed with Robert and found that Franklin's remainder interest was contingent upon his surviving Ada. Georgia appealed to the Oregon Supreme Court.